The Supreme Court of India is the highest judicial forum and final court of appeal of India as established under the Constitution of India, which makes the Supreme Court the highest constitutional court and guardian of the Constitution. The Supreme Court of India consists of the Chief Justice of India and 30 other judges. Articles 124 to 147 of the Constitution of India lay down the composition and jurisdiction of the Supreme Court of India. The Supreme Court has original jurisdiction, appellate jurisdiction and advisory jurisdiction. As the highest court of appeal, the Supreme Court acts as the highest appellate court in India, which takes up appeals primarily against the verdicts of the high courts and other courts and tribunals of India. The Supreme Court has extensive original jurisdiction in regard to enforcement of fundamental rights. It also acts as the court to hear disputes between various governments in the country. As an advisory court, the Supreme Court hears matters which may specifically be referred to it by the President of India under the Constitution of India. The Supreme Court also has the power to take cognizance of matters on its own. The Supreme Court of India possesses the power of constitutional review. The Supreme Court held its inaugural sitting on January 28, 1950. Prior to that, the Supreme Court used to function within the building of the Parliament of India. History: the Supreme Court of India came into being on January 28, 1950. It replaced both the Federal Court of India and the Judicial Committee of the Privy Council, which were at the apex of the Indian court system. Its initial seat was the Chamber of Princes in the Parliament building where the previous Federal Court of India sat from 1937 to 1950. In 1958, the Supreme Court moved to its present premises. The original Constitution of 1950 envisaged a Supreme Court with a Chief Justice and 7 puissant judges, leaving it to Parliament to increase this number. Constitution of the Court. Registry. The Registry of the Supreme Court is headed by the Secretary-General, who is assisted in his work by 8 registrars, several additional and deputy registrars, etc. Article 146 of the Constitution deals with the appointments of officers and servants of the Supreme Court Registry. Supreme Court Advocates. Though as per the Advocates Act, 1961, all the advocates enrolled with the state bar councils can practice across any court in India, Supreme Court Rules, 2013, provide for a special category of lawyers called advocates on records who are registered with the Supreme Court of India after they qualify the special conditions as per the rules. In general, the advocates practicing at the Supreme Court of India can be categorized in the following 3 categories. Advocate on record, an advocate who is entitled under the Order 4 of the Supreme Court of India Rules, 2013 to act as well as to plead for a party in the Supreme Court of India. As per the rules, no advocate other than an advocate on record shall be entitled to file an appearance or act for a party in the Supreme Court of India. Senior advocate. These are the advocates designated as a senior advocate or counsel by the Supreme Court of India or any high court as per the Advocates Act, 1961. A senior advocate is not entitled to appear without an advocate on record in the Supreme Court. Advocates. Any advocate other than an advocate on record or a senior advocate can appear and plead in any matter before the Supreme Court if instructed by an advocate on record. The Supreme Court Building and its architecture. The main block of the Supreme Court building was built on a square plot of 22 acres, and the building was designed by Chief Architect Ganesh Pikhaji de Lalakar, who was the first Indian to head the Central Public Works Department and designed the Supreme Court building in an Indo-British architectural style. The court moved into the present building in 1958. The building is shaped to project the image of scales of justice, with the central wing of the building corresponding to the center beam of the scales. In 1979, 2 new wings, the East Wing and the West Wing, were added to the complex. In all there are 15 courtrooms in the various wings of the building. The Chief Justice's Court, the largest of the courtrooms, is located in the center of the central wing. Mother and child sculpture, a black bronze sculpture of 210 cm height, was installed in lawn of the Supreme Court on February 20, 1978. It portrays Mother India in the form of the figure of a lady. The lady is sheltering the young Republic of India, represented by the symbol of a child, who is upholding the laws of land, symbolically shown 6 in the form of an open book. On the book, a balance is shown, which represents dispensation of equal justice to all. The sculpture was made by the renowned artist Sri Chintamani Kar. Composition, size of the court. As originally enacted, the Constitution of India provided for a Supreme Court with a Chief Justice and 7 judges. In the early years, a full bench of the Supreme Court sat together to hear the cases presented before them. As the work of the court increased and cases began to accumulate, Parliament increased the number of judges from the original 8 in 1950 to 11 in 1956, 14 in 1960, 18 in 1978, 26 in 1986 and 31 in 2008. As the number of the judges has increased, they have sat in smaller benches of 2 or 3 coming together in larger benches of 5 or more only when required to settle fundamental questions of law. Any bench may refer the case under consideration up to a larger bench if the need to do so arises. Eligibility: the person must be a citizen of India, judge of a high court or of 2 or more such courts in succession for at least 5 years, or an advocate of a high court or of 2 or more such courts in succession for at least 10 years, or, the person must be, in the opinion of the President, a distinguished jurist. In practice, the judges appointed to the Supreme Court are selected from amongst the judges of the various high courts in India. To date only 4 judges, namely Justices S. M. Sikri, S. Chandra Roy, Kuldeep Singh and Santosh Hegde, have been appointed to the Supreme Court directly from the bar, that is from amongst the practicing advocates. Appointments in the Collegium: judges of Supreme Court used to be appointed by the President of India, who acted on the advice of the Union Cabinet. However, subsequent to the rulings in the 3 judges' cases, the President is required to appoint judges who have been chosen by the Supreme Court's Collegium, a closed group consisting of the Chief Justice of India and the foremost senior associate judges of the court. The Union Cabinet and Parliament have almost no role to play in the appointment of judges to the Supreme Court or to any of India's 24 high courts. The position of Chief Justice of India is attained on the basis of seniority amongst the judges serving on the court. The collegium system has come under a fair amount of criticism. Former Madras High Court Judge, J. Chandra, once described this method of appointments as a total failure tenure. Supreme Court judges retire at the age of 65, which is 3 years more than the retirement age of a judge of the High Court. Hence a judge at the Supreme Court who have been elevated from a High Court serves at the Supreme Court for at least more than 3 years. However, there have been suggestions, including from the judges of the Supreme Court of India, to provide for a fixed term for the judges there, including the Chief Justice of India. Impeachment: a judge of Supreme Court can be removed by the procedure prescribed in Article 124(4) of the Constitution of India on ground of proved misconduct or incapacity, or judge resigning from his office addressed to the President of India. The procedure prescribed for removal of Supreme Court judge should not be called an impeachment procedure because this procedure is provided only for the removal of the President of India under Article 61 of Constitution of India on ground of violation of the Constitution. Salary: Article 125 of the Indian Constitution leaves it to the Indian Parliament to determine the salary, other allowances, leave of absence, pension, etc. of the Supreme Court judges. However, the Parliament cannot alter any of these privileges and rights to the judge's disadvantage after his appointment. A judge gets 90,000 and the Chief Justice gets a sum of 100,000. Court demographics: in 2000, Justice K. G. Balakrishnan became the first judge from the Dalit community. In 2007 he also became the first Dalit Chief Justice of India. In 2010, Justice Shkapadhyay coming from a Parsi minority community became the Chief Justice of India. Rules: the Constitution of India under S. Constitution of India Part 5 Article 145 Rules of Court, etc. Article 145 empowers the Supreme Court to frame its own rules for regulating the practicing procedure of the court as and when required. Accordingly, Supreme Court Rules, 1950 were framed. They were replaced by the Supreme Court Rules, 1966. In 2013, the Supreme Court enacted new rules, which are called Supreme Court Rules, 2013. The new rules will replace the 1966 rules and will be applicable from August 19, 2014 as published in the Extraordinary Official Gazette dated May 29, 2014. Reporting and Citation. Supreme Court Reports is the official journal of reportable Supreme Court decisions. It is published under the authority of the Supreme Court of India by the Controller of Publications, Government of India, Delhi. In addition, there are many other reputed private journals that report Supreme Court decisions. Some of these other important journals are SCC, AIR, Scale, etc. Facilities available at Court Campus. Following facilities are available for the benefit of the litigants and the parties to matters before the court: court fee vendors, for purchase of judicial and non-judicial stamps as court fee and Supreme Court is payable only by way of court fee stamps. Pass counter, for the issuance of passes for entry to Supreme Court as entry to Supreme Court. Online facility has also been started to assist in this purpose. Medical facilities, a first aid post, a dental clinic, a physiotherapy unit and a pathology lab are functional in the West Wing on the ground floor of the Supreme Court building. Railway reservation, a computerized railway reservation counter has been opened by Northern Railway. Canteen facilities, post office functional since 1958. Banking, a branch of UCO Bank is functioning in the Supreme Court since 1984 and provides services including ATM facility. Judicial Independence. The Constitution seeks to ensure the independence of Supreme Court judges in various ways. In 3 judges' cases, the court held that a Supreme Court judge can be appointed by the President only on the recommendations of the collegium system as mentioned earlier. A judge of the Supreme Court cannot be removed from office except by an order of the President passed after an address in each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of members present and voting, and presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. The salary and allowances of a judge of the Supreme Court cannot be reduced after appointment. A person who has retired being a judge of the Supreme Court is debarred from practicing in any court of law or before any other authority in India. Power to review its own judgments. Article 137 of the Constitution of India lays down provision for power of the Supreme Court to review its own judgments. As per this article, subject to the provisions of any law made by Parliament or any rules made under Article 145. The Supreme Court shall have power to review any judgment pronounced or order made by it. Under Order XL of the Supreme Court rules, that have been framed under its powers under Article 145 of the Constitution, the Supreme Court may review its judgment or order but no application for review is to be entertained in a civil proceeding except on the grounds mentioned in Order XL VII, Rule 1 of the Code of Civil Procedure. Powers to punish for contempt. Under Articles 129 and 142 of the Constitution, the Supreme Court has been vested with power to punish anyone for contempt of any court in India including itself. The Supreme Court performed an unprecedented action when it directed a sitting minister of the state of Maharashtra, Sarup Singh Naik, to be jailed for 1 month on a charge of contempt of court on May 12, 2006. This was the first time that a serving minister was ever jailed. Landmark judgments. Land reform. After some of the courts overturned state laws redistributing land from zamindar estates on the grounds that the laws violated the zamindar's fundamental rights, the Parliament of India passed the First Amendment to the Constitution in 1951 followed by the Fourth Amendment in 1955 to protect its authority to implement land redistribution. The Supreme Court countered these amendments in 1967 when it ruled in Gulnath v. State of Punjab that the Parliament did not have the power to abrogate fundamental rights, including the provisions on private property. Emergency. The independence of judiciary was severely curtailed during the Indian emergency of Indira Gandhi. The constitutional rights of imprisoned persons were restricted under preventive detention laws passed by the Parliament. In the case of Shivakant Shaikla, Additional District Magistrate of Jabalpur v. Shivkant Shaikla, popularly known as the habeas corpus case, a bench of 5 senior-most judges of Supreme Court ruled in favor of states' right for unrestricted powers of detention during emergency. Justices A. N. Ray, P. N. Bhagwati, Y. V. Chandraud, and M. H. Beg, stated in the majority decision, under the declaration of emergency, no person has any locus to move any writ petition under Art. 226 before a High Court for habeas corpus or any other writ or order or direction to challenge the legality of an order of detention. The only dissenting opinion was from Justice H. R. Khanna, who stated, "Detention without trial is an anathema to all those who love personal liberty." A dissent is an appeal to the brooding spirit of the law, to the intelligence of a future day, when a later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed. It is believed that before delivering his dissenting opinion, Justice Khanna had mentioned to his sister, "I have prepared my judgment, which is going to cost me the Chief Justiceship of India." In January 1977, Justice Khanna was superseded despite being the most senior judge at the time, and thereby government broke the convention of appointing only the senior-most judge to the position of Chief Justice of India. Justice Khanna remains a legendary figure among the legal fraternity in India for this decision. The New York Times wrote of this opinion, "The submission of an independent judiciary to absolutist government is virtually the last step in the destruction of a democratic society." And the Indian Supreme Court's decision appears close to utter surrender. During the emergency period, the government also passed the 39th Amendment, which sought to limit judicial review for the election of the Prime Minister. Only a body constituted by Parliament could review this election. Subsequently, the Parliament, with most opposition members in jail during the emergency, passed the 42nd Amendment, which prevented any court from reviewing any amendment to the Constitution with the exception of procedural issues concerning ratification. A few years after the emergency, however, the Supreme Court rejected the absoluteness of the 42nd Amendment and reaffirmed its power of judicial review in the Minerva Mills case. Post-1980, an assertive Supreme Court. After Indira Gandhi lost elections in 1977, the new government of Morarji Desai, and especially Law Minister Shanti Bhushan, introduced a number of amendments making it more difficult to declare and sustain an emergency, and reinstated much of the power to the Supreme Court. It is said that the basic structure doctrine, created in Kesavananda Bharati v. State of Kerala, was strengthened in Indira Gandhi's case and set in stone in Minerva Mills v. Union of India. The Supreme Court's creative and expansive interpretations of Article 21, primarily after the emergency period, have given rise to a new jurisprudence of public interest litigation that has vigorously promoted many important economic and social rights, including, but not restricted to, the rights to free education, livelihood, a clean environment, food and many others. Civil and political rights have also been expanded and more fiercely protected. These new interpretations have opened the avenue for litigation on a number of important issues. It is interesting to note that the pioneer of the expanded interpretation of Article 21, Chief Justice P. N. Bhagwati, was also one of the judges who heard the Admiral J. Balpur case, and held that the right to life could not be claimed during emergency. Recent important cases, among the important pronouncements of the Supreme Court post-2000 is the Kalho case, IR Kalho v. State of Tamil Nadu. A unanimous bench of 9 judges reaffirmed the basic structure doctrine. It held that a constitutional amendment which entails violation of any fundamental rights which the court regards as forming part of the basic structure of the Constitution, then the same can be struck down depending upon its impact and consequences. The judgment clearly imposes further limitations on the constituent power of Parliament with respect to the principles underlying certain fundamental rights. The judgment in Kalho has in effect restored the decision in Golak Nath regarding non-amendability of the Constitution on account of infraction of fundamental rights, contrary to the judgment in Kesavananda Bharati case. Another important decision was of the 5-judge bench in Ashoka Kumarathaka v. Union of India, where the constitutional validity of Central Educational Institutions Act, 2006 was upheld, subject to the creamy layer criteria. Importantly, the court refused to follow the strict scrutiny standards of review followed by the United States Supreme Court. At the same time, the court has applied the strict scrutiny standards in Anuj Garg v. Hotel Association of India, 2G spectrum scam. The Supreme Court declared allotment of spectrum as unconstitutional and arbitrary, and quashed all the 122 licenses issued in 2008 during tenure of A. Raja, the main official accused in the 2G scam case. Black money. The government refused to disclose details of about 18 Indians holding accounts in LGT Bank, Liechtenstein, evoking a sharp response from a bench comprising Justices B. Sudarshan Reddy and S.S. Nijjar. The court ordered special investigation team to probe the matter. Lack of enthusiasm made the court create a special investigative team. Minority reservations. The SC refused to stay the Andhra High Court judgment quashing 4.5% sub-quota for minorities under OBC reservation quota of 27%. Online postal ballot for Indian citizens living abroad. 3-judge bench presided by Honourable Chief Justice Altamas Kabir issued notice to the Centre and the Election Commission of India on the PIL filed by a group of NRIs for online postal ballot for the Indian citizens living in abroad. Recognition of transgender as third gender in law. In April 2014, Justice K.S. Radhakrishnan declared transgender to be the third gender in Indian law, in a case brought by the National Legal Services Authority against Union of India and others. The ruling said, "Seldom, our society realizes or cares to realize the trauma, agony and pain which the members of transgender community undergo, nor appreciates the innate feelings of the members of the transgender community, especially of those whose mind and body disown their biological sex. Our society often ridicules and abuses the transgender community and in public places like railway stations, bus stands, schools, workplaces, malls, theaters, hospitals, they are sidelined and treated as untouchables, forgetting the fact that the moral failure lies in the society's unwillingness to contain or embrace different gender identities and expressions, a mindset which we have to change." Justice Radhakrishnan said that transgender people should be treated consistently with other minorities under the law, enabling them to access jobs, healthcare and education. He framed the issue as one of human rights, saying that, these TGs, even though insignificant in numbers, are still human beings and therefore they have every right to enjoy their human rights, concluding by declaring that 1. Heroes, eunuchs, apart from binary gender, be treated as third gender for the purpose of safeguarding their rights under Part 3 of our Constitution and the laws made by the Parliament and the state legislature. 2. Transgender persons' right to decide their self-identified gender is also upheld and the centre and state governments are directed to grant legal recognition of their gender identity such as male, female or as third gender. Criticism, corruption and misconduct of judges. 2008 saw the Supreme Court embroiled in several controversies, from serious allegations of corruption at the highest level of the judiciary, expensive private holidays at the taxpayer's expense, refusal to divulge details of judges' assets to the public, secrecy in the appointments of judges, to refusal to make information public under the Right to Information Act. The Chief Justice K.G. Balakrishnan invited a lot of criticism for his comments on his post not being that of a public servant, but that of a constitutional authority. He later went back on this stand. The judiciary has come in for serious criticisms from former presidents of India Pratibha Patil and APJ Abdul Kalam for failure in handling its duties. Prime Minister Manmohan Singh has stated that corruption is one of the major challenges facing the judiciary, and suggested that there is an urgent need to eradicate this menace. The Cabinet Secretary of the Indian government introduced the Judges' Inquiry Bill 2008 in Parliament for setting up of a panel called the National Judicial Council, headed by the Chief Justice of India, that will probe into allegations of corruption and misconduct by High Court and Supreme Court judges. Pendency of cases. According to Supreme Court newsletter, there are 58,519 cases pending in the Supreme Court, out of which 37,385 are pending for more than a year, at the end of 2011. Excluding connected cases, there are still 33,892 pending cases. As per the latest pendency data made available by the Supreme Court, the total number of pending cases in the Supreme Court as on April 1, 2014 is 64,330, which includes 34,144 admission matters and 30,186 regular hearing matters. Recently, in May 2014, Chief Justice of India, Justice R.M. Lodha, proposed to make Indian judiciary work throughout the year in order to reduce pendency of cases in Indian courts. However, as per this proposal, there is not going to be any increase in the number of working days or working hours of any of the judges, and it only meant that different judges would be going on vacation during different periods of the year as per their choice. But, the Bar Council of India rejected this proposal mainly because it would have inconvenienced the advocates who would have to work throughout the year. See also: Attorney General of India, List of Chief Justices of India, List of former Justices of the Supreme Court of India, List of sitting judges of the Supreme Court of India, Solicitor General of India. References. External links: Official website, Supreme Court reports, text of all Indian Supreme Court judgments.